Rules Committee have come to order, and thank you very much for allowing us a few minutes to be delayed this afternoon as we prepare for H.R. 2289, the Commodities End User Relief Act. Today's legislation reauthorizes the Commodities Future Trading Commission, CFTC, through fiscal year 2019 and implements several, what I believe and the chairman believe are several important reforms to promote appropriate regulatory structures that allow for economic growth and job creation. Over the past 20 years, our economy has seen financial derivatives employed in new and I believe in innovative and good ways. As a result, it's imperative that the CFTC have the authority to appropriately regulate the marketplace to promote fairness and stability. However, it's just as important that Congress enact policies to ensure that the CFTC does not unnecessarily inhibit innovation or inadvertently harm end users. Thanks to the leadership of the gentleman from Midland, Texas, Michael Conaway, the chairman of the Agriculture Committee, and the ranking member, my dear friend also, Colin Peterson from Minnesota, I believe this legislation accomplishes these goals. Gentlemen, I want to thank both of you for taking time to be here today. And before I get to you, we're going to have a chance to have you turn around just for a second and see if you see a very interesting figure that is on the wall, was just placed there this last week. And it reminds me a lot of our ranking member, Louise Slaughter. But I want you to know that we celebrated this week. We'll quit at the end of this week, but until then, everybody gets an opportunity to note how important her service has been, not only to this Congress, her party, and our country, but that we are really, really proud of that. And I know both of you will want to take 15 or 20 minutes each to just go on and on about that.
Mr. Chair?
But before we do that, the gentleman from Colorado is going to seek his time. Yes, sir.
I was just wondering if it's true that the size of the portrait is indicative of the contribution of the country that the respective chairs have made.
Well, as roll call said today, there's a lot of exuberance in that picture. But they also noted, as we did a couple weeks ago, she now hangs here. So thank you very much. Mrs. Slaughter, you want to welcome our guys here? Welcome. Yeah. All right. Well, so much for that. I want to yield you such time as you can as we get started today for any statement. Yeah. Good. So both of you are no stranger to the Rules Committee. You know that we count on both of you with your expertise, your leadership within both the parties and in the agriculture community. Your viewpoint is enormous, and we appreciate you being here. Without objection, anything you have in writing will be in the record, and we're delighted that the young chairman from Midland, Texas here, gentleman, is recognized.
Well, thank you, Chairman. I want to congratulate Ranking Member Slaughter on her portrait and appreciate the elephant in there. I can't read the cartoon, but I appreciate you including a bipartisan elephant in your deal. What appears to be an elephant, so we appreciate the bipartisan nature of your portrait. But it's and your family. It's pretty cool that you've got all your family. Yeah, that's good stuff. Good stuff. Mr. Chairman, members of the committee, thank you for the opportunity to appear before you today to speak in support of a rule to provide for the consideration of H.R. 2289, Commodity End User Relief Act. First and foremost, H.R. 2289 will reauthorize appropriations for the Commodity Futures Trading Commission, an authority that lapsed in September of 2013. Beyond that, H.R. 2289 represents the bipartisan work completed over the past 3 years to address the challenges and uncertainties that end users are facing in the derivatives markets. In that time span, the Committee on Agriculture held 11 hearings to gather testimony from the end user community, market service providers, and from the full slate of CFTC chairman and rank and file commissioners. Throughout the testimony received, there has been a consistent call to action by the market participants struggling to comply with rules that are needlessly burdensome and a law that is at times unclear. Similar to the reauthorization bill passed by this body with overwhelming bipartisan support last Congress, the Commodity End User User Act is comprised of narrowly targeted changes to the Commodities Exchange Act to provide the right relief to the right people. The reforms in this bill fall into three broad categories. First, this legislation protects customers and margin funds they deposit at their FCMs by codifying critical changes made in the wake of the collapse of bankruptcies at MF Global and Peregrine Financial. Second, this legislation makes meaningful reforms to the operations of the Commission to improve the deliberative process at the agency by providing commissioners with timely information they need to fulfill their duties to the public. It also requires that the commission put in place a more robust system of cost-benefit analysis to help get future rulemakings right the first time and to avoid the endless cycle of reproposing and delaying unworkable rules. And finally, the bill fixes real problems faced by end users who rely on derivatives markets to manage their risks. When it is more costly for those who need these markets to use them, it discourages exactly the kind of prudent risk management activities Congress intended to protect with the end-user exemptions in Dodd-Frank. Accordingly, H.R. 2289 will relieve end users from the unnecessary and likely unintentional burdens stemming from new rules regarding record-keeping, registration, and definitions. A sampling of the relief that is as follows. The bill relieves grain operators, farmers, agricultural counterparties, and commercial market participants from overreaching record-keeping rules that require the recording of all forms of communication that may possibly lead to a trade. The bill does so by specifying that keeping written records of the final material economic terms of an agreement will be sufficient for market participants who only manage their own money. America's utility companies often rely on contracts that contain an option to change the amount of a commodity delivered, but that still result in actual physical delivery of the commodity. This bill prevents these risk management tools from being classified as swaps, thus eliminating a source of needless confusion for power plant operators and their counterparties and those relying on relieving these companies from unnecessary compliance costs that would trickle down to millions of household customers. In response to CFTC's narrowing of acceptable hedging strategies down to a limited enumerated list, the bill provides a more workable definition of bona fide hedging as it relates to position limits. The bill will preserve end users' ability to hedge against anticipated business risk. H.R. 2289 reaffirms our commitment to protecting American farmers, ranchers, manufacturers, and other businesses from costly new burdens stemming from policies meant to protect them in the wake of the 2008 financial crisis. The committee reported a bipartisan bill which makes meaningful improvements for market participants without undermining the basic goals of Title VII of Dodd-Frank Act to bring in clearing, reporting, and electronic execution requirements to swaps transactions. I'd like to close by thanking members of the Ag Committee who have worked to advance this important legislation. I'm especially appreciative of efforts of Mr. Austin Scott, Chairman of the subcommittee that oversees the CFTC, as well as Mr. David Scott, the subcommittee's ranking member, both of whom joined me as original co-sponsors of the bill. I'd also like to share my thanks to Chairman Sessions for joining me as a sponsor of the bill as well. His vote of confidence is important to our work. As I detailed at the start of my remarks, the members of the Ag Committee have done a tremendous amount of work to get us to this point. Without question, this bill is better because of the bipartisan hearings and legislation that we've been working on together for the past 3 years. I'd ask that the rule reflect the bipartisan nature of our work and continue to ensure that H.R. 2289 is focused on helping end users manage and comply with the important reforms under Title VII of Dodd-Frank. Again, thank you for your time today. I'll be happy to answer your questions.
Mr. Chairman, well done. Thank you very much. Mr. Peterson is former chairman of the Agriculture Committee and a deep and dear friend of this committee. We're delighted that you're here. And the gentleman is recognized.
Well, thank you, Mr. Chairman, and we wish Ms. Slaughters was a member of the Ag Committee so her picture could be over there and bring some beauty to that facility over there. Would be much needed and appreciated. So, Mr. Chairman and Ranking Member and members of the committee, thank you for the opportunity to be here today. And I wished I could say that I'm supporting this bill, but I'm not. And, you know, unfortunately, this is not a bipartisan bill. In fact, the only member on our side, I think we had 2 members that supported the bill on our side of the aisle. Last session, we had a reauthorization bill that I believe passed the House, which I did support. And that included a provision that I really don't like very much, and that's the cost-benefit analysis part of this bill, but I supported it last time because that was really the only thing that was in there other than the straight reauthorization. And I think at the time, I don't think that had the other provision in there that said that you could use, it didn't allow you to use the cost-benefit analysis in a lawsuit to stop the rule, basically. As I understand it, this whole idea came from the Obama administration asking each of their agencies to do cost-benefit analysis. And so there was an executive order put out. That's what's in this bill. Except in the executive order, it says that it's not to be used in any legal situation. So you can't use that cost benefit to sue that you haven't done it accurately or to hold up the rule. That was taken out. So what's in here, I would say, could be used by folks to string out a rule another year, 2 years, however long a lawsuit took. So some people say, well, why aren't you supporting this bill this time because you did last? Well, that's one of the things that I have a concern about, but that's not the main concern that I have. There are some other things in here that are more problematic. Now, I'll start with the easiest ones first. This is not the end of the world, but we had a dispute at the CFTC between Chairman Gensler and one of the commissioners. And this did not go well. And the commissioner, I guess the chairman thought was leaking information, whatever. Anyway, so there wasn't stuff shared between the chairman and the members. So there's, the chairman is gone, Gensler is gone, this commissioner is gone. There is no problem now, but there's been provisions put in this bill to fix that problem, which no longer exists. And I would argue is going to make it harder for whoever runs this commission, not only the chairman, but the members in the future. And I just think it's misguided. And, if that was the only thing in here, I could probably live with it, but I just think it mucks up the situation. There's also a concern that I have with an amendment adopted in the committee to the core principles of the swap execution facilities that were created in Dodd-Frank. And this provision is a big break to opaque voice brokers at a time when the CEFs are struggling to provide robust pre-trade price transparency. That's one of the reasons we set these CEFs up, so that is on an electronic platform, this stuff is available, and it helps people that are in the market be able to figure out what's going on. You have voice brokering going on, that's not transparent, that's done in the dark, and it goes against one of the main goals of the original core principles of Dodd-Frank. We also just recently received a note from CBO that estimates that the bill's new cost-benefit analysis requirement and the cross-border rule, which I will talk about next, would require an extra 30 full-time employees to implement, and would cost an additional $45 million over the first 5 years. Well, the argument around here that there isn't enough money that's gone into the CFTC in the first place. And what they've asked for to implement Dodd-Frank is significantly below what they've been given. That whole controversy, the majority has provided flat funding or reduced funding for the agency over the last 4 years. And all this is going to do is just further take away the ability for them to do what they're supposed to be doing. So that's another problem that I have. Now, on this cross-border situation, I think this is the most troubling of what's in here. And that has to do with they're trying to harmonize our rules with the new rules that are being adopted in Europe. And, they are doing a similar kind of thing over there with their industry that we are. But they are doing it a little bit different, like they always do. And so they've been over there negotiating with these folks for quite a while. And as I'm told by the chairman, with probably 85% of what they're working on, they're ready to finalize probably here in the next month. The other 15% has to do with this equivalency issue, which is recognizing the European system when it's equivalent to the U.S. system. And the problem is the Europeans have drug out their rulemaking so that we haven't got a fixed target to be able to do this part of the rule. They just delayed it from June 15th to December 15th. So that part is ongoing. But what this bill does, it stops the whole process. So the 85% that we could get done here in June is going to be stopped by what we're doing in this bill. And it just seems like you're throwing the baby out with the bathwater to me. And what I'm worried about in this regard is that we're going to get back into the situation we were in before Dodd-Frank, and that is these big banks who, in my opinion, have not learned a damn thing from what happened in 2007. You know, and you can go look at Richard Folds' speech yesterday to see that. You know, what they were doing before that was that they would go to London and the Goldman Sachs or whoever and say, if you guys don't back off on this regulation, we're going to move to the United States. And we're going to move all our banking to the U.S. because we like their regulations better. Then they'd go to New York and say, if you don't back off on this, we're going to go to London with our operation, because they had offices in both places, and they worked us against each other. And there's no question they did it. And if we adopt this bill, you're going to put us back into the same situation again. You know, and I don't know, whatever all you think about the economy, I am not all that confident about what's going on in the economy. And I think we've created another bubble in the stock market with this no interest deal that we're involved in. People have put their money in the stock market because there's no other place to go, run it up beyond what it should. And I'm just worried that we're going to have another meltdown kind of a situation. And this bill, you know, it's like I said, it's probably not the end of the world, but we're making it more difficult for the commission to do what we asked them to do. And you're taking away some of the things that they need. So I would very much like to support this bill. I would like to see us come out with a bipartisan situation we could agree to. Mike and I tried to work it out. We couldn't. You know, so I am going to oppose the bill, and I think it's misguided. And I'm not going to offer any amendments or do anything because I know how this place works. But I think at the end of the day, if this thing gets through the Senate, you know, we'll have an opportunity to, if some kind of bill gets through the Senate, we'll have an opportunity at the end of the day to do something that we can all get behind and that is bipartisan. So with that, I'd be happy to take advice or answer questions, whatever on your mind. I yield back.
Ms. Peterson, thank you very much. The committee, I think, is interested in finding great progress, and certainly we, or at least I realize that what we've got to do is let people, give them a greater opportunity, and I am sorry that it did not meet that mark for you. And I will tell you that I believe that what we're really trying to accomplish in the bigger scheme of things is to streamline the operations. Both of you know far more about, and one of our members here, Mr. McGovern, sits on the Agriculture Committee, and you understand the huge implications of these things, but I'm hopeful that the debate's going to help me to get closer to understanding your points, and certainly Mike, so thank you very much. Mr. Cole?
Thank you, Mr. Chairman. I don't have any particular questions. This legislation is probably more complex than anything I can handle, but I do want to begin by thanking both the gentlemen for being here. They're my favorite members of Congress, too. I respect the most. Frankly, I was hoping that you would come to the same opinion and I could vote yes with a clear conscience, not worry about anything. But I know that you have substantive differences. I'm going to have to spend a lot more time looking at it. But I respect both of you as legislators. I know how capable you both are, quite frankly, and look forward to listening to your points that you care to make either tonight and during the course of the debate. So, again, thank the gentleman for the effort to arrive at a consensus, and perhaps somewhere down the road that'll be possible. Yield back, Mr. Chairman.
Thank you very much. Mrs. Slaughter.
Thank you, Mr. Chairman, and thank you, gentlemen. I appreciate it. Mr. Peterson, you brought up most of the concerns that I have here. I think I certainly share what you're saying about your concern about the unraveling of Dodd-Frank for reasons that are totally obscure to me. We went through such an awful shock and such an awful time, and so many people were hurt grievously that we would even risk doing that again because the banks want to do it. You're right about Mr. Fall's statement that, what was he said? He's coming out from where he's been hiding all this time. Dodd-Frank strengthened the CTFC considerably, gave them a lot more to do. It wasn't reauthorized, and certainly we have not given them the money commensurate with what they're going to do. CFTC already does cost-benefit analysis, does it not? So why would we require them?
Yeah.
Yeah, why in the world would we put something in to have them do that again? Mr. Conway, you want to speak?
Well, they don't have cost-benefit analysis. They have a requirement to give them a lick and a promise. The experience that the agency had over the 50 rules that they did was that their cost-benefit analysis had no substance through any of those. And the industries that are now having to comply with all those rules out there, their actual costs are dramatically larger than it was estimated for the agency, when the agency did their analysis. So this bill would require the chief economist to do those cost-benefit analysis in a rational way that actually.
Are you willing to give them the personnel and the money that they need to do that? Does that happen in this bill?
They got an extra $35 million this year in December in the omnibus to their agency. So that's not flat funding. They got an additional $35 million this year.
But what would it cost for them, Mr. Peterson, in your view?
Well, according to
be able to
CBO,
do-
estimate we got was $45 million for over 5 years.
Oh,
But that includes, in addition to the cost benefit, it also includes these cross-border stuff.
That's really, the cross-border, I think, is concerned. Now, that's already being negotiated, right, as we speak.
Well, he's.
But the bill would cut the negotiations off.
Well, yeah,
If
well,
went fast.
not exactly directly, but I think it would have
Well,
the
there'd be
effect.
no point in them.
It would have the effect of doing it the way I
Right.
read it. Yeah.
The cross-border notion is really troubling to me. As I understand it, and correct me if I'm wrong, but the institutions can take the laws of either the United States where they're chartered or someplace else where they could save more money. Is that about it?
No, ma'am. The institutions don't have the choice.
Yeah.
It's the regulators themselves that have to decide whose scheme should be controlling in their particular
Right.
jurisdictions. And so the cross-border fit, whatever that $45 million is, that's going to be there no matter what we do, whether we reauthorize this group or not. You'll have institutions having to comply with laws in a variety of jurisdictions. So it's the agreements within the institution, the regulatory institutions themselves that decide how they're going to regulate the transactions in their jurisdiction that have counterparties or parties to those transactions somewhere else. And so the institutions don't have a choice on which one they comply with. We're just trying to prevent them having to comply with multiple ones.
How does that differ from what we do now?
Well, can I clarify?
Yes.
You know, he's right. And the institution doesn't get to choose. But when I was chairman, I went over to Europe. I spent time in London, spent time in Germany, you know, with their regulators, spent time with the folks that worked on all this stuff. And what was going on is what I said earlier. These banks would come in and lobby them, you know, and their folks, that if they didn't give in on this, they were going to move their whole operation over. So that's where the pressure comes, you know, and it's a race to the bottom. What we're doing is setting up a situation where it allows these folks to arbitrage these regulators against each other to get the lowest regulation. That's the problem, you know, and, you know, we've been chasing ghosts here to some extent. In the original Dodd-Frank bill, it says very clearly that this does not apply to end users. I don't know how many, you know, bills that we've passed to try to clarify this end user thing, which is not being caused, the problem is not being caused by the CFTC, it's being caused by the prudential regulators, by the bank regulators that are requiring margins on this stuff that doesn't have anything to do with us. You know, and that, you know, and I guess it's fine to put this language in here, but it doesn't do anything. If you want to fix this, you got to fix it in financial services, but nobody does that, you know. So I just worry. I made the mistake of voting for the Commodity Modernization Act in 2000. Probably the worst vote that I've ever made here, because that's what gave legal certainties to these derivatives.
Yeah.
Before that, it was considered by the court gambling, which is what it is.
Indeed.
You know, and especially in these naked swaps, where people are getting involved in these derivatives that have no connection to them whatsoever. It's like me buying insurance on your house, and then I get paid if it gets burned down, and I got nothing to do with your house. I mean, that's the kind of stuff that we authorized in that 2000 bill, which
people
at
lost
that time, there
their
was $70 billion of derivatives. In 8 years, there were 700 trillion, you know? And it set off this whole thing that got us in this collapse. I don't want to be part of anything that's going to get us anywhere close to that in the future. That's where I'm at.
If I might,
Certainly.
with respect to the regulatory arbitrage that my colleague mentions, that was going on while the rules were being developed. What we're saying with the cross-border issue is that our rules are developed and that we're asking the CFTC to set out a matrix that says, here's what we look to in the other 8, quite frankly, or 9 major markets across the world. What does their scheme need to look like so that it's equivalent to ours? And if it's equivalent to ours on outcomes, then they should recognize it and the folks could comply with it. But there's no way to arbitrage it now. Those days are behind us, and my colleagues fighting a war that no longer exists. So our rules are in place, and if our rules are the best set, and the CFTC and their wisdom and their experience can't say that the Brits or EU or Singapore and these other jurisdictions, that their rules are not as good as ours in outcomes, then our rules apply. So the colleague is arguing something no longer is the issue.
I think I'd feel better about that if the Agriculture Committee last week hadn't done away with the country of origin labeling because you're worried about the trade bill, which, as far as I'm concerned, means that we're willing to gamble on health here.
No.
So that we won't get taken to court to that.
Yeah, cool has absolutely nothing to do with food safety.
Investor state thing.
It's
I
the-
realize it's different. No, I understand that.
Okay.
But I'm just saying, having seen you do that, was it last week? It makes me wonder a little bit about our security here for the United States, particularly on the international
Well,
issues.
a mandatory marketing program, it has absolutely nothing to do with security of the United States. If you want your beef to come from Nolan Ryan Certified Angus beef, then he's perfectly willing to be able to do that. What we're saying is we lost the WTO case 4 times in a row. It's done. There are going to be retaliatory measures put against our American producers, and we're simply responding to the facts as they are.
And that's exactly why this trade bill that we're going
Well,
to
this
make
has
you do
nothing to do
here
with the
is
trade bill, ma'am.
dreadful.
This has nothing to do with
Because
trade
it doesn't go to WTO, it goes to this 3 tribunal attorneys. They're corporate lawyers who are going to decide. And I believe, in my mind, I'm pretty well convinced that that's why Ag did away with country of
No, ma'am,
origin labeling.
I'm the one who did it. It was my decision to make that
Yeah.
statement.
Because you didn't want to get sued.
Huh? No, we've been sued. We've lost.
Well, all right.
We've lost 4 times, and the only thing left is to decide what the penalties are.
So then in
I'm
order to
simply-
have this trade bill, we're going to have a race to the bottom.
No, ma'am.
Look,
No, ma'am. That's.
well, I don't
that's
want to
not
get
even
off on this
remotely.
because this is a whole other debate, and I'd be happy to have it
Well,
with
we'll
you.
Get that next week.
I'll have that rule
But
up
as a
next week.
microbiologist, and I know 90% of the seafood coming in here already is basically not inspected. Most of it's imported that we eat. I'm very, very much concerned about what we're doing here with clean air and clean water. And if our laws are going to keep them from making money, the investor states, we're going to lose, right? And so we will do what you guys did before, and that's to
We
do
all
away
want
with
to
it.
breathe clean air and drink clean water, ma'am. I'm not sure.
Oh,
what
that's
you're asking.
coming.
Ma'am.
Okay, all right.
Okay.
Well, in any case, let me read the administration's policy. They've studied this more than I. Strongly opposes the passage that undermines the efficient functioning of the CFTC, posing a number of organizational procedural changes that would undercut the efforts over the last year to address end-user concerns, offers no solution to address the persistent inadequacy of the agency's funding, is one of only 2 federal financial regulators funded through annual discretionary appropriations, and the funding the Congress has provided for it for the past 5 years has failed to keep pace with the increasing complexity of the nation's financial markets. The changes would hinder the ability of the CFTC to operate effectively, threatening the financial security, again, of the middle class by encouraging the same kind of risky, irresponsible behavior that led to the Great Recession. And if it should come to the president in its present form, he would veto it. I ask unanimous consent to put this in the record.
Without objection.
Thank you. I yield back.
Gentlewoman yields back her time. The gentleman, does any Republican seek time? Gentleman from Washington.
Thank you, Mr. Chairman. I just wanted to make a couple comments. I am the other member of the Rules Committee that also sit on the Agriculture.
Oh, good.
And so, not that I have tremendous insight, this is a complicated issue, as you can appreciate from the
And the
last
gentleman
discussion.
does farming or ranching?
I am a farmer in my real life.
farmer.
That's right. Yeah, appreciate
Good.
that. Mr. Cole was absolutely right that this is complicated. I had the benefit of going on my very first Codell on this issue. Chicago in the middle of winter is a very good place to visit. But we had a good visit with the folks at the Chicago office of the commission, met with a lot of the people that deal with this issue every day, the users, the farmers, the grain elevator folks, the commission member, excuse me, the staff from the commission, who I should say do a tremendous job for us, and we should be proud of their work. A lot of questions come to mind. I'm going to be working on this tomorrow on the floor, so I'll save a lot of my comments for then. But just wanted to, I guess, give Chairman Conaway an opportunity, and also Ranking Member Peterson, to talk a little bit about some of the reforms that are in Title II. It seems as though if we have an opportunity to improve on a system that we have seen issues with, seen problems come up, whether the people are different or not, it seems to me we ought to seize that opportunity. So if you could expound a little bit on that just a short time, I would appreciate that. You know, everything that goes through this place is a process of improvement, and it seems like an opportunity that we should not pass up. Mr. Conaway.
I appreciate it, gentlemen. We did add a stricter cost-benefit analysis requirement. It is based off of the President's order, and we did add one caveat to it, and that is that the agency would need to take into account the costs, its own internal costs of competing ways to regulate something, so that we'd understand that they're doing it the most cost-effective way for them in their agency. With respect to making sure all 5 commissioners have access to the information they need to do their job, that problem didn't exist before the previous chairman, and I do agree that the current chairman is much more reasonable. But in an attempt to make sure it doesn't happen again, the reform would require that all the other 4 non-chair members of the committee would be able to get access to the information they need to do their rules. There are also some tightening up of the rules that allow the staffers themselves get to issue certain proclamations or orders from the agency without the commissioners being involved. We add some language there that would say the commissioners need to be involved in that reaction in that action as well. So those are some of the ones that we added to the agency itself that are we believe appropriate and would strengthen the administration of the agency.
You'd like to make any?
Well, I just, I don't know how much harm it does, but I don't think it's necessary, and I don't think it necessarily does any good. And I predict if Republicans take over and have a chairman, he'll be in here trying to repeal this. That's what I think.
The administration. Yeah, that thing.
Take over the White House and appoint the chairman and the majority. I'll bet you they'll be in trying to repeal this. That's what I think.
We're on the lost leader list.
Gentlemen, seek additional time.
I have no further questions, Mr. Chairman.
Thank you very much.
Thank you very much.
Yes, sir. Mr. McGovern?
Chairman, I would thank both the chairman and ranking member for being here. I have the privilege of serving on the Agriculture Committee as well. On this issue, I side with Mr. Peterson. I'm worried about the inadequate funding for the CFTC. I'm worried about kind of asking more and more from this agency without properly funding it, setting it up to fail. I'm worried about these new requirements, and I worry about we're going down a road where we're slowly but surely chipping away at Dodd-Frank and all these protections, and we're going to end up in a situation in the not-too-distant future where we're going to say it reminds us of the situation that got us into this economic crisis to begin with. But having said all that, I will say more about this on the floor tomorrow. But I'd like to ask unanimous consent to insert in the record the Consumer Federation of America's letter to all members of Congress in opposition to H.R. 2289.
Without objection, I'll be entered in the record.
I yield back my time.
Gentleman yields back his time. Gentleman does not seek time from Florida. Gentlemen, I want to thank you for taking time to be with us today. I tell you that both of you being here is important to this process. And Mr. Chairman Conaway, I want to thank you for taking time. I know you've set aside a good bit of your time to be here today, and I appreciate you very, very much. If you'll please both make sure that you leave anything you had in writing for our awesome stenographer, that will allow her an opportunity to decipher between Minnesota and Texas the language that was spoken here today. I have to do that on a regular basis for her, but thank you very much. I wanted to take a point of personal privilege to acknowledge that I have several young men that are a part of a intern program in my congressional office. We had about 23 young men and young women who we have just arrived for an intern program, and today we have Simone from Southwestern University. We have Joe from Villanova, who is from, Simone Beleja is from Arlington, Texas, and Joe Farmer is from Villanova University, Dallas, Texas. Kyle Reed is from Lufkin, Texas, attends the University of Texas. Parker Collins, Southern Methodist University, attends from Frisco, Texas. Joe Lund, the University of Mary Washington in Fredericksburg, Virginia. And Brian Peck from Texas A&M, who's from McKinney, Texas. And I want to thank all of them, each of them, for taking part of their summer to be with us and being at the Rules Committee today, and thank them very much. Hope we do well enough where they want to come back, Louise. Yeah, thank you very much. Okay, we have now finished. Is there anybody else that has anything they'd like to discuss, Rules Committee? Before we started today, Mrs. Slaughter and I briefly spoke about our understanding that the United States Senate today is debating and voting on the the NSA, the Freedom Information Bill, and that we had decided that we would try and string out this committee meeting for at least 5 extra minutes, pending an outcome there. It has not happened. So what we're going to do is go ahead and wait. We're going to have to be in tonight for vote. So whenever they're through with their voting, we'll put it together. We'll be subject to the call of the chair coming back, and hopefully to add that in here once we see what that looks like. I want to thank the committee for their time today. So we're going to adjourn subject to the call of the chair. This closes the hearing portion of H.R. 2289, Commodity End User Relief Act, and we will come back at the call of the chair. Thank you.
Testing, testing. Testing.
Yeah. Rules Committee come to order, and thank you very much for allowing us to get our work done. Chair will now be in receipt of a motion.
Mr. Chairman, I move the committee grant H.R. 2289, the Commodity End User Relief Act, a structured rule. The rule provides 1 hour general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Agriculture. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for purpose of amendment, an amendment in the nature of a substitute consisting of the text of Rules Committee, print 114-18, provides that it shall be considered as read. The rule waives all points of order against that amendment, the nature of a substitute. The rule makes an order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to a demand for division of question. Rule waives all points of order against the amendments printed in the report. The rule provides 1 motion to recommit with or without instructions. Finally, Section 2 provides that the Committee on Appropriations may at any time before 5 p.m. on Friday, June 5th, 2015, file privileged reports to accompany measures making appropriations for the fiscal year ending September 30, 2016.
You've now heard the motion from the gentlewoman from Grandfather Community, North Carolina, Vice Chairman of the Committee, Mrs. Fox. Is there amendment or discussion?
Yes, Mr. Chairman, I have an
Gentlewoman's recognized.
amendment. I move the committee grant H.R. 2289 an open rule, so all members have the opportunity to offer amendments to the bill on the floor.
Good, thank you very much. We had a very lively discussion today, most interesting, and I appreciate the gentlewoman's amendment. Is there further discussion? Seeing none, the vote will now be on the motion, on the amendment from the gentlewoman from New York. Those in favor signify by saying aye.
Aye.
Those opposed, no.
Roll
Those
call,
have no say.
please.
Gentlewoman asks for a roll call vote.
Ms. Fox? No. Ms. Fox? No. Mr. Cole? No. Mr. Cole, no. Mr. Woodall? No. Mr. Woodall, no. Mr. Burgess? No. Mr. Burgess, no. Mr. Stivers? Mr. Collins? No. Mr. Collins, no. Mr. Byrne? No. Mr. Byrne, no. Mr. Newhouse? Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern? Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
2 yeas, 7 nays.
The amendment's not agreed to, not agreed to. Further amendment or discussion?
Yes, Mr.
Gentleman
Chairman.
from Florida.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment to H.R. 2289 by Representative Waters, number 3, which would prohibit the CFTC from waiving bad actor disqualifications against arising under a law other than the Commodity Exchange Act.
Thank you, Mayor, very much. Discussion? Vote will now be on the Hastings amendment. Those in favor signify by saying aye.
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 Those opposed, no.
Mr. Chairman, I ask for a roll
Gentleman
call.
asks for a roll call vote.
Ms. Fox? No. Ms. Fox? No. Mr. Cole? No. Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Collins? No. Mr. Collins, no. Mr. Byrne? No. Mr. Byrne, no. Mr. Newhouse? Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern? Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Mr. Chairman, no.
I'd like to ask if I could have the gentleman from Ohio is registered.
The gentleman is not recorded.
The gentleman has not been recorded yet. The,
It was my amendment.
That's just a hint.
Mr. Stivers, no.
clerk will report the total.
2 yeas, 8 nays.
Amendment's not agreed to. Further amendment or discussion? Vote will now be on the motion from the gentlewoman from Grandfather Community, North Carolina. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it, the ayes have
And
it.
we would like a roll call because we think we'll hear about this again, right? Okay.
Ms. Fox? Aye. Ms. Fox, aye. Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Stivers? Aye. Mr. Stivers, aye. Mr. Collins? Mr. Collins, aye. Mr. Byrne? Mr. Byrne, aye. Mr. Newhouse? Ms. Slaughter?
No.
Ms. Slaughter, no. Mr. McGovern? Mr. Hastings? Mr. Hastings, no. Mr. Polis? Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk will report the total.
8 yeas, 2 nays.
The motion is agreed to, And the gentleman, Mr. Newhouse from Washington, will be handling this for Republicans,
And Mr. McGovern for the Democrats.
and Mr. McGovern for the Democrats. I think we're all aware that evidently this afternoon,
Yes.
the Senate did pass
And it's on
the
its way
House
to the White
bill,
House.
and it's on its way to the White House, and so there is no need for further action by the Rules Committee. And we were waiting to find out that answer. I want to thank each of you for coming back.
Indeed.
This is my idea that we have no additional Rules Committee meeting this week, so we are now completed our work. Thank you very much.